Why he didn't raise it at the beginning, who really knows what is going on in his head. But the bottom line is,
join in if you wish. Marshall, would you lead us in the pledge?
I would. Thank you, Your Honor. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. This is Senior Justice Michael Cherry. I've been appointed by the Supreme Court to handle this matter. This is case number A829038, T. Matthew Phillips versus Abrams Law Firm, Marc DiCiero and David Schoen. Will counsel state their appearances, please?
sure, good afternoon, Your Honor. Marc Cwik on behalf of defendants David Schoen and Marc DiCiero.
Your Honor, Joseph Garin on behalf of Jennifer Abrams and the Abrams Law Firm.
Good afternoon, Your Honor. May it please the court. Initial T period, Matthew Phillips, California State Bar Number 165833. I am not licensed in Nevada.
Okay.
Justin Martin just appearing as
He's
assistant
with
to
my office.
him.
Okay, great. All right, I have the joint submission by the parties of outstanding motions to be decided. What's your pleasure? It's Friday afternoon. I've got all afternoon. I'm not going anyplace. What can I do for you today as far as the joint submission? Is there a particular motion you want to hear first? I know that the big motion, of course, is the anti-SLAPP motion, but there seems to be other motions that at least plaintiff would want to do, or maybe defense would do. What's your pleasure?
Judge, I think that the motion to strike the fugitive pleadings and the filings that are beyond what's contemplated by the anti-SLAPP statute, that needs to be addressed so we can understand what the record is and what the court would be considering in deciding the anti-SLAPP motion. And from my perspective, the statute contemplates a pleadings filed or complaints filed. The defendants can file their anti-SLAPP motion. Plaintiff then has the opportunity to ask the court for discovery or to simply file an opposition, and then the replies filed, and that's it. And then the matter is supposed to be heard on an expedited basis. What we had happen here was Mr. Phillips, instead of living with that motion, opposition, reply, he filed a surreply and then late objections and all other kind of stuff to kind of supplement the record. There's an amended brief. These are all things that supplemented and augmented the record beyond what the statute contemplates. Wasn't helped by the fact that there was COVID going on and we were moving between a lot of judges, but that's important that we isolate what it is that needs to be considered, and that in essence is just the anti-SLAPP motion and the opposition and the reply. So I think that it needs to be addressed in that order so we know if the court's inclined to consider all the extra new information that was added beyond what the statute contemplates, or if we're going to argue based on what was filed under the statute.
And I would just point out, Your Honor, in addition to what Mr. Garin said, there was a briefing stipulation that was entered in this case. It was entered on August 12, I believe, of 2021, and we actually set briefing on that. The plaintiff's briefing was due on August 16. Our reply was due August 23 of this is 2021, and then the hearing date was August 26th, and that was for Judge Williams, which didn't go forward because he had recused himself. We actually have a stipulation on the record that was the schedule for briefing. So everything else that got filed after that is obviously outside not only the statute, as Mr. Garin pointed out, but also outside of the stipulation of the parties. So I agree with him that we probably should resolve what is going to be left out of the record so we know what to deal with when we get to the motion itself.
Okay. What I pulled out for today's hearing, I read the Johnson hearing that Susan Johnson had, which got interrupted at the very end, so at least it gave me an idea about the case. I also got the defendant's special motion to dismiss and the joinder. Then I got the plaintiff's opposition to defendant's renewed anti-SLAPP, and then I pulled the reply. I'm just used to doing that. I'll certainly hear from plaintiff as to what you think the extra information is necessary for me to make a judgment on this case. Go ahead.
Thank you, Your Honor. I would say that what's happened here is we filed some objections to their evidence. They have hundreds of pages of emails that I believe are just manifestly irrelevant. So we filed some evidentiary objections. But yes, there was a stipulation for a briefing schedule in connection with the anti-SLAPP. But the stipulation, as I recall, was just as to dates. There's no affirmative prohibition on you can't file extra documents. And yes, it's true, the local rules do set up an ABA format for briefing. Motion, opposition, and reply. There's not a strict prohibition in local rules on supplemental filings. Generally speaking, a party would file for leave, but if it's a day or two away, in my experience, I've been a lawyer for 31 years now, it's in the judge's sound discretion whether or not they'll accept a pleading. Now, why did I file these extra pleadings? Well, in their reply brief, remember the ABA format, when they did the reply, they added a new exhibit, a brand new exhibit that wasn't part of their principal motion. So I believe because they opened the scope of the evidence and added a new exhibit in their reply brief, the interest of fairness required that I should be able to file a SOAR reply to address the evidence that they bring up for the first time in the reply brief. In addition, I filed an affidavit concerning subject matter jurisdiction. And as Your Honor knows, subject matter jurisdiction can be raised at any time, whether it's for the first time on appeal, litigant can mention subject matter jurisdiction. And the exact issue with subject matter jurisdiction is this, that they have to prove that Phillips bombed a school or shot up a school, whatever it is they're trying to prove. But it's my argument that if they're going to do that in their affirmative defense, so to speak, it's an affirmative defense is just like a cause of action, but in the inverse, if you will. And as part of the elements of their affirmative defense, they have to prove that Phillips committed a crime. And my thought is, wait, this is turning into a de facto criminal trial, which would be unconstitutional. Because Article 1, Section 8 of the Nevada Constitution says, quote, no person shall be tried for a crime but upon indictment. And so because I've never been tried for a crime, I don't think that they have the right to put on evidence and try to prove that I committed a crime. If they want, and this is really, I think, the only way they can win the case, if they were to ask the court to take judicial notice of a certified copy of conviction that I bombed a school or that I shot up a school. But absent that, it's my position that they can't turn this into a de facto criminal proceeding. They can't put on evidence saying that, yes, you know, we saw this guy with a machine gun or whatever crazy allegations they're making. So I believe there was legit reason for me to oppose their extra exhibit that they tried to sneak in on the reply. And I think also that I can raise subject matter jurisdiction at any time. So I brought it up because I think that's worth mentioning, the Article 1, Section 8 argument. I put it in writing so it would be memorialized. I believe I would be able to argue these issues in open court, so I think it's almost superfluous you know, whether they try to strike them now, because I would be arguing the same points anyway. So my preference, without taking up too much more time, is I would like to get right to the anti-SLAPP. So,
Well, first of all, DiCiero 2.20, I think it's subsection I, says supplemental briefs could only be filed if there's leave of court. So the idea that there's nothing in our rules that say that you can supplement because it's within 2 days of a hearing or something like that, that's actually false. That's contrary to DiCiero 2.20. The idea that we somehow added an extra exhibit, Your Honor, we referenced this document that he's referring to in our initial motion. If you need me to, I can locate it in the briefing. I can point out to you where he referenced it. He's referring to, I think, a TRO that had been entered in his family court case. The fact that we attached that document to the reply and responding to his opposition doesn't suddenly mean we brought up something entirely new. It was briefed in the initial motion itself. So there's nothing new here at all. This is just a ploy to try to make it sound like we did something wrong so that he can now try to get in extra briefing. And if you look closely at his briefing, and he has, there's a lot of these filed, in these documents that he filed, he's going into all kinds of new stuff all the time. These are just backdoor ways of trying to continue to brief and add new issues, like this issue of subject matter jurisdiction. That was never briefed in the initial briefing. And all of a sudden now he wants to inject this under the guise that somehow, because the court can consider subject matter jurisdiction any time, he can just go ahead and start filing additional documents. Why he didn't raise it at the beginning, who really knows what is going on in his head. But the bottom line is, this is all new stuff, and it's not supported by our rules like he claims. And the idea that he flips the standard too as far as what we have to prove on a SLAPP case. We don't have to come in and show what he's saying. This is stuff we'll get into in the actual briefing. But this idea that we have to come in with a criminal conviction or something like that, it's false. The bottom line is Judge Ochoa, in a decision and order, made findings that he did certain very bad things. And that's what my client's comments are based upon, is that and things that they found beforehand. He doesn't point out, for example, that in February of 2020, he filed lawsuit against his judge, Judge Ochoa. I think it was February 7th, 2020. He attaches as an exhibit to his public filing a copy of a TRO that was entered in that case. So this idea that we have to somehow come in and do this weird criminal thing is just absolutely preposterous and false.
What about the fact that the defamation supposedly occurred before the Judge Ochoa's?
He's trying to shift the timeline. I understand what he's trying to do. The bottom line is this: if you look at my client's declaration, I think it's paragraph 13 and then into 14 in the declarations they submitted. They talk about during the election cycle, they discovered information about what was going on in his family court proceeding. That stuff was put in the public record by him way in advance of the first day that's alleged in his complaint. This is, like I said, the complaint was filed February of 2020. The first thing in his second amended complaint, I think, is like July of 2020. So they had access to all types of things. The orders are accessible. There's information that they got that, to try to say it's all related to the December 19, 2020 Judge Ochoa order, that's false. My clients, that is not what they say in the declaration. And so the timeline shift that he's trying to do to try to fit everything in this little box doesn't work. That's my answer to that. But remember, he put into the public record the TRO document in his filing before against Judge Ochoa. It's a federal court filing, public record.
Well, let's go on with the SLAPP motion. That's what his preference was, so I'll go ahead and honor his preferences to allow you to go ahead and do your motion to dismiss under anti-SLAPP.
I'm going to move over here. It'll be easier to address you. Also, I realized there was a transcript. I had looked at the transcript. It looked like, because there's a bad audio quality. Right. So I'm probably going to cover some of the same ground.
I don't mind.
Because here we've got a microphone in front of me. Hopefully it'll capture everything and the court reporter can get everything down. But all right, so my clients are David Schoen and Marc DiCiero, and we moved to dismiss when a second amended complaint under the SLAPP statutes. I'm going to start just by laying the groundwork, so to speak, of what has to happen today, just to start over. So there's two prongs to the analysis when you've got a SLAPP motion. Under prong one, we have to show by preponderance of the evidence that my clients are engaged in a good faith communication in furtherance of the right to petition or the right to free speech in direct connection with an issue of public concern. If we establish that, then the burden shifts to plaintiff. Under prong two, the district court has to find that we met our burden, and the court must then determine whether the plaintiff has demonstrated with prima facie evidence a probability of prevailing on the claim. So when you look at that, we have a preponderance of the evidence standard. He's got a prima facie standard. His standard is actually higher than ours, just based on the plain language of the statute. Now, there are two components to prong one that I just described that I need to go through with you. The first component is that the comments that are at issue fall into one of the four categories of protected communications enumerated in NRS 41.637. And then the second component that I have to show you is that the communication is truthful or is made without knowledge of its falsity. So let me get to prong one, and I want to provide background again. I realize some of this may be in the transcript. I probably have a little bit more just to help you understand what's going on because you're new to the case. But the first thing you'll note is that if you look at my client's motion, even double-sided pages, it's pretty thick. It's about an inch thick or whatever. You compare that to plaintiff's, response, and it's pretty thin, even the complaint. And there's a reason why that exists, and it's something I think is important to point out just to start out, and that is plaintiff is trying to diminish the entire context from which this dispute arose. He's trying to fit something in a little box, like he just tried to do just now when we were starting argument, trying to argue somehow that this court doesn't have subject matter jurisdiction because of this theory he's come up with under criminal law. And he wants to detract away from the actual context, and that doesn't happen. He doesn't get to control the context. And that simply isn't going to work. Because the facts of this matter are that the dispute, if you look at the timeline of everything, you start with the documents, look at everything we briefed, the timeline starts during the 2020 election cycle. And there was an ongoing debate publicly at that time in the political arena about the Nevada legal system with a particular focus on the family court system. That might not necessarily be unique. I think every election cycle has issues that come up about the court system. But let me see if I can streamline the issues for the court's benefit. So during the pertinent factual period, my clients, David Schoen and Marc DiCiero, were officers in Nevada Court Watchers PAC. So this is a political action committee registered with the Nevada Secretary of State. And they were administrators of their Facebook page for their PAC, which was called Nevada Court Watchers. And the purpose of their PAC, and I'm just going to quote this, the purpose is to provide information, guidance, and resources to the voters of Nevada regarding the affiliation of judicial and non-judicial candidates with corrupt, immoral, and other organizations as it directly impacts the practice of law in Nevada. And so this is an open public forum, their group, where members openly discuss matters surrounding the Nevada judiciary. They discuss judicial elections, judicial selection and discipline, legislation related to judicial matters, and other related public interest matters. And back in 2020, during the election cycle, their page had hundreds of members. Now, as they state in their declarations, they take the more moderate position in public debate about the Nevada judiciary. And again, it's all laid out in their declarations. Now, so that's side one. Now take side two. Side two was an organization known as Veterans in Politics International. And this is an organization which states as its goal, they support judicial candidates who will protect people from, quote, their own government in a culture of corruption, end quote. That's their words, not mine. And they claim the judiciary is corrupt. They advocate for reform of the election process and judges. They advocate hardline reforms of the Nevada judiciary. They had a Facebook page themselves. Their Facebook page, I believe, had thousands of followers. They were newer on the scene than my client was back in 2020. Importantly, Veterans in Politics had a listserv where they would send out messages to a large number of people. The Nevada Supreme Court in the Abrams v. Sansa case found that a listserv is a public forum. So this is a crucial fact. And Facebook has also been found to be a public forum. Now let's get the plaintiff. Who's the plaintiff? Well, he's a litigant in Nevada's family court system during this time period, and even before. As he noted, he's a California attorney. He's not licensed in Nevada. His ex-wife, Amber Phillips, filed for divorce in the fall of 2018. It's all from public records. And the family court judge was Judge Vincent Ochoa. It was a very contentious divorce from what you can see by reading what was going on in the case through the documents that we filed. And it resulted that there was a temporary order for protection against domestic violence that was entered by the Domestic Violence Hearing Master on September 18 of 2018. So here's an order entered, matter of public record, in 2018. And then after an evidentiary hearing was held on November 2nd, 2018, a decision was entered on November 5, 2018 regarding that order. Later in the divorce, then there was a decision order entered by Judge Ochoa on December 19, 2020. But both of those orders, the TPO and the decision order of the Judge Ochoa, made findings about a threat by Mr. Phillips to shoot up his son's school. I'm going to quote this. I think it's important to make it for the record. And the TPO said, on September 26, 2018, the campus initiated a lockout to ensure safety for students and staff. This described action was taken in response to an allegation that the adverse may shoot up the school. Adverse obviously referring to Mr. Phillips. The decision or order dated December 19, 2020 said, quote, plaintiffs learned that defendant made phone calls to the child's school and threatened to shoot up the school, which resulted in the lockdown. And the defendant referring to Mr. Phillips in that order. And we addressed this in our motion, our reply. Some of this is addressed in the declaration of our clients, how they got that information and so forth. But the bottom line is, there's a matter of public record, and since the TPO was entered, Mr. Phillips was actively engaged out there speaking out against the Nevada judiciary, and he was filing lawsuits against judges. Like what I said before, he filed a lawsuit against his own judge, Judge Ochoa, who had apparently blocked him on his Facebook page, attached a copy of one of the documents related to the TPO to his complaint. He also sued Judge Bryce Duckworth in federal court on December 29, 2020, again related to his family court case. Basically, arguing his case wasn't litigated within 6 months, I believe, so that it wasn't properly done within the time periods that they should have been. That basically was his argument. But he's a litigious guy suing the court system even. That's an important point to note. Now, plaintiff has been engaged also with veterans in politics. And he's aligned with veterans in politics. No matter what he says today, the evidence shows to the contrary. Like I said, it's an inch thick of stuff that you have in front of you. He has moderated multiple veterans in politics candidate interviews and forums. He's published numerous politically motivated articles and statements and VIPI emails, some of that's, like I said, attached. We included a photograph in our briefing showing him at a VIPI event, Veterans in Politics event. We've attached documents showing his involvement with VIPI. It's Exhibit C of our motion. He himself runs many Facebook pages claiming the Nevada judiciary is corrupt. The one that's commonly cited is the Atomic Court Watchers page. That's his Facebook page, which he uses for that purpose. On that page, he regularly was attacking my clients during this time period. I'm sure there's probably stuff even up to the current date, if you go back all the way, that he's been attacking my clients on his Atomic Court Watchers page. But I would direct the court's attention to the March 6, 2020 VIPI email that we attach as Exhibit C. And I think it's important to show the evidence that we have before you of the stark contrast between these two groups and Mr. Phillips' involvement with that group. If you look at page 5 of the March 6, 2020 email, and I'm just going to quote it again for the record. I think it's easiest so you can hear it. It says, quote, "To gain a real-world perspective, the truth hits, exclamation point. I-Team contacted renowned civil rights attorney T. Matthew Phillips, Esquire, who stated, quote, Las Vegas is world famous, not just for gambling, shopping, fine dining, and nightlife, but for its burgeoning family court corruption, end quote. Phillips decries Las Vegas family court. Phillips lamented, quote, it's a den of iniquity where civil rights go to die, end quote." You have pretty egregious statements against the judiciary, obviously. Then they go 2 paragraphs below on that same page. The email goes on to state the following. They say, quote, "Our I-Team rode straight into the heart of the enemy camp. We visited Nevada Court Watchers, a shill group on Facebook," end quote. So attacking, in that email, my client, and Mr. Phillips' name is mentioned in this email. Then in the next paragraph, the email goes on to further attack my client's Facebook page. And I'll quote again, quote, "Nevada Court Watchers is home of Nevada Court Watchers PAC, a political action committee which vows to pursue targeted, highly funded campaigning against any judicial candidate who, 1, seeks a VIPI endorsement, 2, attends a VIPI event, 3, gives money to VIPI, or 4, appears on a VIPI radio program. Hide your kids, hide your wife, NCW PAC is on the warpath, exclamation point." Another example would be the July 28th, 2020 email we attached to Exhibit C. In that email, they attacked my client, Nevada Court Watchers, my client's PAC at Nevada Court Watchers. They attacked NCW, as I'll call it. They're calling them a corrupt group. They mentioned Mr. Phillips was enlisted to write an article for Veterans in Politics in that email. And the email ends with the following statement. It says, quote, "VIPI has respect for Attorney Phillips for doing the right thing and standing up to Clark County corruption." So right there, in these emails that he wants to avoid, subject to whatever objections he's trying to get out of it, he's clearly embedded in this. So naturally, you've got my group, my client's group on one side, you've got VIPI on the other side, and they're going to clash during an election cycle because they're groups that are involved in obviously political activity. And competing social media campaigns between the sides occurred. My client views Veterans and my client's NCW views VIPI to be an organization which tries to improperly influence judges through intimidation, manipulation, and control. And we attached as an exhibit H in our motion papers an order of a recusal that had been filed on September 5, 2017 in a family court matter involving Judge Bryce Duckworth, the one that he sued that I mentioned. And the order notes improper communications that Mr. Sanson of VIPI, who's the head of VIPI, had with the court, where Judge Duckworth notes, I'll just quote from that order, it says, quote, the only purpose of his communication with the court was to influence and intimidate the court through a corrupt communication outside of court, end quote. So you can see my clients came information showing that the VIPI, in their view, is trying to corrupt the system. And so during the 2020 election cycle, my client's NCW group targeted judicial candidates and judges seeking re-election in the state of Nevada who were associated with or paying money to or saw endorsements of or otherwise were involved with or legitimizing VIPI. Their group NCW circulated multiple targeted political advertisements on social media and search engines against judicial candidates who associated with VIPI. You can see there's a lot going on between these parties, and it made the newspaper, as we point out in our briefing, on February 7 of 2020, the RJ had an article, and I'll just quote from it. They say that VIPI and NCW were, quote, now engaged in a very public row over each other's motives and methods, end quote. So I think you get a flavor of sort of what was going on during that time period. Now, Plaintiff, he was advancing the views of VIPI and he acted in the campaign against NCW, my client's group, during the 2020 election period. But he didn't stop there. In 2020, he injected the quote-unquote family court controversy, which is his words, by the way, into public discussions, and he admits this in his opposition brief. He actually uses this terminology in his opposition brief. But he attacked my clients in public forums on Facebook and accused my clients of operating a controlled opposition group to protect corrupt judges and attorneys from criticism. So he went on the attack. Whether or not he attacked, the bottom line is he's associated with VIP, but he opened the door for counterattacks in the political arena, certainly for my clients to respond to personal attacks against them. And that's where the SLAPP laws come into play. Now, as noted in my client's declarations, they researched publicly available information about Plaintiff, and I pointed this out earlier to you. And they found that he was a litigant in the Clark County Family Courts, and they pulled up copies and orders of documents and so forth from the 8th Judicial District Court and the Nevada Supreme Court. He had attached documents to an appeal he filed and so forth. There's a lot of places they got documents over a long period of time. And so contrary to plaintiff's arguments, they didn't rely exclusively on just the December 19, 2020 order. If he tries to argue that's just a red herring, a fallacy. That's not true. Like I said, the Judge Ochoa's lawsuit was filed on February 7 of 2020, and so forth. And now, under a statute in Nevada, under NRS 125.110, findings of the court, orders made on motions and judgments are not sealed from public view in family court. There's no automatic sealing of anything. Those documents can be downloaded. People can go online. Unless later a judge for some reason seals something, that stuff's publicly available. So this stuff was available during pertinent times for my client to obtain. And appellate records that you are on the Supreme Court, appellate records are generally also open for public inspection unless somehow they later get sealed. And so my clients naturally responded to plaintiff's attacks by commenting what they found in their research. And they, plaintiff will try to slice every word or whatever. It doesn't work because the bottom line is my clients simply use terminology to capture the gist or sting of the findings in the orders they saw. They use rhetorical hyperbole at times, which is permitted under defamation law. Many of the comments are done in the form of political satire, the common things that you see in politics. And the obvious purpose of the statements, when you read it all in context, is to respond to the plaintiff's attacks on them, to call into question, Mr. Phillips' character and background, to convince others to think twice about associating with him, VIPI, his statements for VIPI and so forth. He's promoting VIPI. He's being quoted in emails, as I just pointed out. And so, they have a right to respond and to those attacks and to say, hey, this person's been involved in the family court system. He doesn't point out to you in all his negative statements about the family judiciary, about what really went on in his case and what was found against him. He doesn't point that out. So they had a right to respond. But unfortunately, here we are now with this SLAPP lawsuit that he has filed, and here we are. All right, so let's get a little further into analysis. I think I hopefully gave you a really good background. You can really see what's going on. I maybe went a little longer than I wanted to, but I wanted you to really see what's going on here. Because it can't be diminished, or whatever he tries to do later, it can't be diminished. It's very broad, it's very, very clear what was going on between these parties. Now, the first component is that the comments at issue fall into one of the 4 categories of protected communication that's enumerated in the statute, which is NRS 41.637. The category at issue here, I'm just going to argue this one for purpose of today. You've read the transcripts. I don't think I need to get into more than one, because I only need to show one. But it's category 4. It's clearly on all 4s here. Which is a communication made in direct connection with an issue of public interest in a place open to the public or in a public forum. That's NRS 41.67 subsection 4. And that's actually the primary category 2 that we discussed in our motion papers. And so we do have an issue of public interest here. As I just pointed out, the context of where these statements arise from, we've got 2 political sides involved in an ongoing public debate about the Nevada court system, its judicial officers, rulings coming out of the family court system, how fathers are treated in the family court system, all those type of things. You've got these 2 parties, the BIPI and NCW, who are involved in politics, commenting on each other. You've got one of them, incorporating statements from Mr. Phillips, as I pointed out. We've got Mr. Phillips out there on Facebook bad-mouthing my client's PAC, that is, and my clients. And so, everything that's, all these comments he's alleging my client said on Facebook derive from public information, that I mentioned, from the orders and so forth, things that they found out in their research. Now, and we were here last time arguing, I didn't get a chance to address this from the transcript, but plaintiff essentially tried to say that I didn't establish that this was that this is in the public interest. So I'm going to make sure to do that right now and make it very clear this is 100% within the public interest. And there's a 5-point analysis that courts use to determine that. And I believe you were on the court that actually held this, the Shapiro v. Well case. I believe you were one of the authors of that opinion, or concurrence, but you were involved in that, I'm pretty sure. That was Shapiro v. Well, 2017. And there's, let's see, this. I think there's five things that I got to go through. So number 1, public interest is not equated with mere curiosity. This obviously based on the lengthy, facts I just gave you what was going on. There's nothing here about mere curiosity. Plaintiff injected his own experiences in the family court system and his court case in the public dialogue. He filed a lawsuit against his own judge about his own court case. And how he's being blocked on Facebook and he can't comment and his rights are being violated. I mean, there's nothing that's just mere curiosity here. And what I did was I went back. I took the cases that were cited in the Shapiro v. Well. I wanted to go and try to go back to see where does that term mere curiosity come from, because it wasn't really discussed in the case, and it appears it dates back to a 1971 California case, because Nevada obviously relies on California law for SLAPP. That even says that in the statute itself nowadays. But there was a case called Briscoe v. Reader's Digest Association. It was 483 P. 2nd 34, and what they basically say is mere curiosity would require like total remoteness in time. So basically, like if my client's pulled up, he got a traffic ticket 20 years ago and he never paid the fine, and suddenly now he got charged with a misdemeanor or something. It has no relation to what's going on with the dispute between the parties. It's way remote. That's what they mean when they say that it has to be with more than mere curiosity. Something like that would be mere curiosity. But in this case, they're talking about things that were happening in his divorce case. He's attacking the family court system. He's a litigant in that system. There's no possible way you could have that being just mere curiosity. So I think we clearly satisfy the first element. The second one is a matter of public interest should be something of concern to a substantial number of people. A matter of concern to a speaker in a relatively small specific audience is not a matter of public interest. And here, as I pointed out earlier, the number of people reviewing veterans in politics emails, and they have the listserv, and so forth, and Nevada Court Watchers Facebook page posts and so forth. Like I said, you had thousands of people that were watching the VIPI people. You had hundreds at that time. Again, they're new on the scene, but the Nevada Court Watchers, was up and running. It had hundreds of people watching. So clearly, you don't have this small itty bitty number of people. So you satisfy the second factor very, very easily. And again, I pointed out that in Abrams v. Sanson, a listserv can be a public forum. So the fact that he's sending out emails and commenting about my client and so forth, clearly you've got something that's going to a substantial number of people. The other issue is that domestic violence is a matter of public interest to a substantial number of people. That's actually found in California law. The S.L.A.P.P Foundation for National Progress case, 1999 case, it's 83 Cal Reporter 2nd, 677, supports that conclusion. And people take very seriously today, obviously, issues of domestic violence. That's definitely something that's a matter of public concern to a lot of people. And if somebody's claiming the system is corrupt, yet they've been found to commit domestic violence, that's clearly in the public interest. The third factor is there should be some degree of closeness between the challenge statements and the asserted public interest. The assertion of a broad and amorphous public interest is not sufficient. Well, clearly there's closeness here. Plaintiff was attacking the family court system and injected into that discussion his own family court case, as I pointed out, so bringing it into the public interest. He filed a lawsuit against Judge Ochoa, his family court judge. That lawsuit was being commented on even in the VIPI emails. The fact that he had sued Judge Ochoa. The orders entered in his family law case, and the findings from those orders all fall clearly within the public interest, as I point out, for the other elements. So you obviously have a degree of closeness between what my clients were saying and the dispute that was going on between all of these parties. The fourth factor is the focus of the speaker's conduct should be the public interest rather than a mere effort to gather ammunition for another round of private controversy. Again, there's no private controversy here, as I demonstrated going through the emails, and you can look at all the posts. It's all out in the public. There's no private controversy. It's a public controversy, clearly, because of the context in which it was happening. And again, two political groups competing with each side, trying to get attention in the public forums. Plaintiff being cited in the VIP emails again, circulation on the listserv, Facebook. All those factors obviously weigh in favor of finding that the focus of the speaker's conduct wasn't public interest. It wasn't for some private little controversy. And then the fifth factor is a person cannot turn otherwise private information into a matter of public interest simply by communicating it to a large number of people. Again, it's the same exact issues I just went over. Plaintiff interjected his family court system into the public discourse on Facebook and the VIP emails. The information is not private, it comes from public sources. As I pointed out, orders are obtainable for public viewing under NRS 125.110. The lawsuit, obviously in federal court against Ochoa, was public. He attached a protection order against domestic violence to his filing. So that obviously brought it into the public and his own doing. And he even attached a TPO to his appeal to the Nevada Supreme Court. So there's so many places you can show it was interjected into the public sphere. So this wasn't some situation of taking something and trying to turn it into a public interest by communicating to a large number of people. Anybody could access this. And so, as you can see, all five factors are clearly satisfied to have that this be determined to be in the public interest. The one also very important point to throw in here is that under Nevada's anti-SLAPP case law now, which follows suit with California, we hold that we define an issue of public concern broadly. And that's been found in the Smith v. Zilberberg case and also the Coker v. Sasson 2019 case. You are a concurring judge on the Coker v. Sasson case. So I know you're familiar that we're applying broadly now in Nevada because that's what the case says. Moreover, let me point out that, and this is something we got into in our motion a little bit, case law establishes that there's an expectation in the law that if you're involved in open public debate like Mr. Phillips was here, you're going to be subject to personal attack. People's character and credibility are often questioned in that arena, and that's to be expected. And that also derives from case law that we cited in our briefing. But if you've got Plaintiff out there in public forums, involving himself in the activities of the EIPI, in a photograph, moderating one of their forums, being quoted by them, commenting on them in public sources, making negative statements against my clients and so forth, clearly he's opened himself up to attack, and it's all in the public interest. And so, you can even go a little further than that even. We cited 2 cases in our briefing. I mentioned one already, the Civil Youth Foundation for National Progress case from 1999. If you look at that case, there was a political consultant who had brought a defamation suit against a newspaper after it published an article about custody proceedings involving the consultant where 2 of his former wives testified he engaged in physical and verbal abuse. The defamation case was dismissed on anti-SLAPP grounds, and the California Court of Appeals held that domestic violence is an extremely important public issue in our society, and found that domestic violence testimony to be an issue of public concern. So that case, directly on all fours, supports our position here. In his opposition, Plaintiff tried to avoid that case. If I recall, he was trying to distinguish it somehow, trying to distinguish himself as somehow being apolitical or something crazy like that. But they obviously fail. I mean, the very name Veterans in Politics International has the word politics in it, and he's involved being quoted by them. I mean, he can't avoid that. I mean, simply he can't avoid that. He used his Facebook page, Atomic Court Watchers, to attack my clients who are operating the PAC, the Court Watchers. He brought himself into the political sphere by his own actions, his own attacks. So nobody could ever look at Plaintiff's activities here and think he's not political, or apolitical, I think he's trying to say in his briefing. He is political. He's involved in a group with the name politics in its actual name. The other case we mentioned in our briefing that is sort of guidance here is the Selig case. It's 119 Cal Reporter 2nd 108. It's a 2002 California case. And that case held that when a person injects him or herself into public affairs, the person opens himself up to public scrutiny. That case had a little bit different factual background, but no less, it's still important. It was a television show that generated debate about the status of society where people are willing to go on a television show and marry a complete stranger for money. And the Court of Appeals held that the show generated public interest, subjecting the plaintiff to public scrutiny and ridicule. And they applied the SLAPP statute to think statements were made in that case. And the issue in Selig was not as shocking as someone who would engage in physical or verbal violence even. So something less than what he was found to do in his court case was found to be subject to SLAPP in California law, is my point. And therefore, clearly, when there's issues of domestic violence involved, clearly it's a matter of public interest. So it's clear from all of the exhibits and Facebook posts and so forth that we've satisfied the public interest requirement of Category 4. And I think I probably adequately addressed his claim that I didn't establish that element. Okay, now the second element that we have to go through in Category 4 of the statute is that the place is open to the public or in a public forum. So I show you the public interest is met. I have to show you this actually occurred in a public or open to the public or a public forum area. And there's absolutely no dispute that Facebook has been determined by case law to be a public forum. Nevada case law was Stark v. Lackey. It's a 2020 case in the Nevada Supreme Court. The California case, Wilbanks v. Wolf, which is a 2004 case, talked about web-based websites being a public forum. And also, as I mentioned, Abrams v. Sanson, a listserv can be a public forum. So we have the public forum issue established in this case very, very easily. So that shows we have public forum. Now let's move to the component 2 of prong 1, which is we have to show the statement is truthful or made without knowledge of its falsehood. This element is met for many reasons. If you look at Stark v. Lackey, the case that I just mentioned from the Nevada Supreme Court, that held that under the preponderance standard, an affidavit stating that a defendant believed the communication to be truthful or made them without knowledge of their falsehood is sufficient to meet the defendant's burden on the first prong of the anti-SLAPP analysis. And they submitted declarations. This is not, you don't have before you a motion that isn't supported by declarations. We have declarations, setting forth their belief that the communications were truthful and made without knowledge of falsehood. There's nothing contradictory in the record, because everything's based on public available information that we've attached and I pointed out to you. Plaintiff put in issue these orders and so forth. They're obtainable. They were entered from court proceedings, evidentiary hearings that happened. The documents speak for themselves. Court can take judicial notice of their existence, I believe, even. None of those court orders have been overturned. He did file an appeal in his family case. It was not nothing that I'm talking about today was overturned in the appeal. He even tried recently to file a writ petition outside of that appeal, trying to interject some new issues like this. I think it was about the issue of this criminal argument or whatever, that the court couldn't have jurisdiction to and made these findings. The Nevada Supreme Court basically said, hey, you should have brought this up in your appeal. It's not the right location to deal with this now in a writ petition after the appeal. So these are orders that are now final orders even, and so he's stuck living with them.
What if they're not true, though? What if it's not true? What if there was no evidence whatsoever, really, that except for Ochoa's finding the fact that he threatened to blow up or shoot up the school?
Well,
I'm worried about that.
For me, the bottom line is there's a presumption of correctness, obviously, in court orders that exist in the law. We are allowed, that goes to the second element, or second part of this. You say which is truthful or is made without knowledge of falsehood. So it falls under the without knowledge of falsehood side of that. It would still be protected, because how are my clients supposed to know if, in theory, none of this happened like you just said? Let's say it was false. They're relying on findings
So
in
good
the court.
faith has no meaning in this statute.
I'm sorry?
Good faith has no meaning in the statute. No investigation is necessary. In other words, you just take whatever you find in the record and that's it.
Well,
That's good faith.
I'm not aware of any authorities, and I've combed as much as I can. I'm not aware of any authorities that would say that in this context, a party cannot give good faith and fair credit to a finding of a
What
judge
about
in the
Rosen
case.
versus Tarkanian? You guys even cited Rosen versus Tarkanian.
For which part, I'm sorry?
Truthfulness.
Well, in that case, they talked about gist or sting in the early Tarkanian. Basically, it didn't have to be verbatim even. As long as it was within the wheelhouse of the gist or the sting, in that case, it was protected. And that's again what I said before. This all falls within the gist or sting in the analysis. But again, I don't think that if it turns out in theory that something was actually false, but it's in a court order that is entered and has never been overturned. He had an opportunity to obviously go and try to overturn it, whatever, but it's never been overturned. My clients can rely on that. That just falls under the second part of prong one, which is then it's without knowledge of its falsehood. If I were to take, I do appreciate your concern, Your Honor, but if we take that all the way to its logical conclusion, what my concern would be, then there would never be anybody ever be able to get out of a SLAPP case. There would be a lawsuit and just somebody would try to say, look, here's something that the judge didn't consider as false, and now all of a sudden they're in a situation where they relied on a court order, and now they're saying they can't rely on it. That would upend the whole procedure. It would upend all the elements of it, in my opinion. So it just falls under the without knowledge of falsehood side.
Just, I've been a lawyer since 1970. I've been a judge for like 25 years now that I've become a senior judge. 8 years on this bench, and then 12 years
You've
in the
definitely done a
Supreme
lot.
Court. And I see where this is going, and I see two organizations, and believe me, I'm very familiar with veterans in politics ever since it started. I know Sansone very well, and I'm familiar with the fellows who do Nevada Court Watchers. And this is like opening a can of worms as to every single divorce case that's handled in Clark County. I mean, this is incredible that this happened as it happened. I'm not happy with the facts here, and I worry about the fact as the truth or falsity of that statement. Now, Mr. Phillips just said to me that they didn't know about the court order when they first said that he threatened to shoot up the school. You're telling me that's not true, that what he said is not true?
I'm saying you follow their declaration. The declaration talks about investigations they did before that order came into effect. It's paragraph 13, I believe. Did they set out every little thing in that paragraph? They did not, but it is clear that there's available information in the public record that they clearly got their hands on. They talk about the Judge Ochoa lawsuit. The Judge Ochoa lawsuit talks about there being findings of domestic violence. This is way in advance of any comments. They have access to this information. So whether or not they rely exclusively on the December 19, 2020 order is really insignificant because the information is out there available to be obtained even before then. And they say that they did research and they found a I don't remember the exact language.
What was the research?
Let me pull the declaration. Find it, Your Honor. So they say plaintiff's tactics in his campaign against Nevada court watchers and Nevada court watchers PAC caused me to question the accuracy of his allegations and his motives behind his various internet campaigns and his lawsuit against Judge Ochoa. So that see they're referencing Judge Ochoa puts you in the early 2020 timeline. Both Marc DiCiero and I researched plaintiff's campaign and lawsuits, as well as underlying accusations made by plaintiff. I discovered a concerning history of domestic violence by plaintiff against his ex-wife and terroristic ideations directed at his child's school. In other words, while alleging that Judge Ochoa is a corrupt judge, plaintiff conveniently omitted that the custodial decisions in his case were based on plaintiff's own egregious misconduct against his wife and minor child. So you can see they're doing research, they say right there, they're finding the lawsuit, they look through the record that it was available, and they then use that information to respond. Then in the next paragraph, they say further, on December 19, 2020, following an evidentiary hearing, then Judge Ochoa entered all that stuff. By use of the word further, they're saying, like implying later, then we found this on December 19, because the statements were going from 2020 to 2021, I believe, based on the allegations in the complaint. So they clearly had access to and found information way in advance of the December 2020 order.
But you're telling me that there was no statement that he threatened to blow up the school prior to Cho's finding?
No, there was. I mean, in the 2020.
What was it? Just tell me what it was.
I believe I read it.
Was it somebody that called him up and said, guess what, I want to tell you something?
In the TPO document on September 26, 2018, 2 years earlier, it says, on September 26, 2018, the campus initiated a lockout to ensure safety for students and staff. This described action was taken in response to an allegation that adverse may shoot up the school. That's where they're getting it from. It's from 2 years earlier.
Did they use the word allegation when they first said it? When they first said he threatened to blow up the school, did they say it was an allegation?
I'd have to look at all, and there's different comments they made. Again, if they did not, that would fall under the gist or sting again. Basically the general, it's no different than in Tarkanian and versus Rosen, where they talked about like working for a corporation versus owning a corporation or different things. They said it was still, as long as it's within the general gist or the sting, that it's covered. The standard isn't that strict, based on the case law that's developed.
This is a little stronger than the Rosen and the Tarkanian issues. I'm very familiar with that case and with the people, with Danny Tarkanian and Jackie Rosen. But I'm just worried about this. I'm worried that they didn't do sufficient investigation before they to even decide whether there was any truth or falsity to the term that he tried to blow up the school. That's all I'm trying to find out. I sure would like just a record as to exactly what they knew and when they knew it. I mean, it sounds like the Watergate. What did they know and when did they know it?
The issue, I'm not aware of any case law he has cited that says that before you just start quoting from court orders and so forth, you have to do your own investigation of the validity of those court orders.
I'm talking about before the court order.
But the court orders starts in 2018 before they even formed the PAC. They wouldn't even exist.
You're talking about the TPO that said he allegedly threatened to blow up the school.
I'm talking about, there's documents, other things that were filed.
Tell me about that. Let's make a record on this so that in case I find in your favor in the case of appeal, for God's sakes, let's make a record on all this about good faith communication and public concern.
Well,
You've done a great job on public concern, but I'm worried about good faith communication.
Well, the things that are there are the things that are stated in the declaration and the exhibits. I've got it all in the record. There's nothing else that I have in front of me that I can think of to put in other than what I've already told you from the record that we have. But they all are discussing this issue of threatening to shoot up, blow up a school. So that's the information. I mean, I don't think there's anything more required for me to show, or from the case law doesn't say anything about doing an investigation. There's nothing in Nevada jurisprudence I'm aware of that says that.
And the burden is on the plaintiff in this matter to request discovery, which was not
Which
requested.
he did not request.
I understand.
He relied on the record, and what he relies on are just 2 sheets of paper. One is some letter that the school sent, and the other thing was a document that he's calling a police report, which you just mentioned you've been a lawyer for so many years and a judge and a justice. I mean, that's not a police report. We know what they look like. They've got signatures on it. There's boxes that are filled in, dates, time. I mean,
Yeah.
that's just, I don't know where it came from. It's not even authenticated. I don't know if it came from his family court case. He doesn't say anything at all. He wants to argue about our evidence, but he doesn't say anything at all where this stuff comes from. And plus, he's using it to draw a conclusion about officer findings. I know from all the years of practicing auto accident cases and other stuff that, generally speaking, the conclusion of an officer isn't even evidentiary. You can call the officer to testify what he saw, what he viewed, things like that. But he's trying to use that to say, look, I couldn't have done it because of some line in a document that's not a police report, that's not authenticated. They have no idea where that came from at all. And so he has a prima facie burden today. And how does he meet his burden on the record before you? So even if you think there's an issue with what I'm saying, he's got a bigger issue. He hasn't come forward with anything to the contrary. And there's no requirement of any kind that my clients had to go out and do an investigation on the corridors. I'm not aware of any authority that says that. And if it was there, it's certainly from California law, which is a lot more law than Nevada, he's a California lawyer, he would have cited that information if it existed. I don't think it exists. I've tried myself to find things on this. I've never found anything on that. So essentially, if you were to rule that way today, I think you'd be creating something that's not in existence in the case. I'm trying to guide you from what we have, what the current state of the law is, and how it's applied. And I noticed, when I look at the opinions of the Nevada Supreme Court over the last 10 years or so, the majority of them appear to be in favor of SLAPP, applying it broadly.
Oh, yes, there's
no question.
I sat through all those
many
conferences for a long time on anti-SLAPP thinking, where are we going with this? What are we doing ourselves here?
And many of those rulings that were in favor were reversing the lower court.
Oh, yes.
In fact, most of them, I think, are reversing, which is why we're asking you to grant it outright, because it looks like you said, the trend is to apply it broadly. The one case you concurred that I had mentioned, the Coker case, you concurred it's supposed to apply broadly. So I understand your concerns, but the state of the law is we apply it broadly, and there is no obligation that they do anything more than they did here.
Is there anything else you want to add before I go to Mr. Garin? I want to hear about Ms. Abrams. I'm not sure exactly where she stands on this. I know she joined in this motion.
Well, I think by a lot of my comments I covered some of the last things I was going to say. If you want Mr. Garin to address the court, I'm happy to yield some time to him, for sure.
Just make a record. I understand she's joined in this, so that's fine. But what about her conduct with Mr. Schoen and Mr. DiCiero? How do you pronounce his name? DiCiero?
I think it's DiCiero.
DiCiero.
DiCiero, I believe.
Your Honor, if I can briefly just touch on, you asked a question about the good faith or truthfulness or good faith. If you look at Judge Ochoa's decision on page 7, this is Exhibit E to the motion that Mr. Cwik filed. Section 19, beginning at line 13 and a half. At the time of the TPO hearing, the child attended school at Corral Academy, Centennial Hills. The school, quote, campus initiated a lockdown to ensure safety for students and staff, end quote. This action was taken in response to an allegation that defendant may shoot up the school. This cites amended decision filed November 5th, 2018 in the TPO action. So I think that gives some context. You're looking for some information, some data. I hope that's shed some light on it. But your question is, how is it that Ms. Abrams is involved in this? And that's a great question. We're still scratching our head because we provided a declaration that said that it's not her Nevada Court Watchers page. She doesn't direct the postings. She doesn't endorse the postings. She doesn't ratify the postings. What she has is these two co-defendants are employees of her law firm. They make these postings, sometimes they do them when they're work, sometimes they do them when they're not at work. But it's not at her direction, it's not with her knowledge or approval. She doesn't ratify these statements. And we originally filed our motion, or I'm sorry, our joinder, as a joinder and also a request for summary judgment. And we attached an affidavit that said, basically set forth all the facts to show that there's not a basis for vicarious liability against Ms. Abrams or her law firm. There's been no opposition to that declaration from Ms. Abrams, where she unequivocally says, not me, I didn't do this, I'm not directing these statements, I'm not publishing these statements, it's not my webpage, it's not me. He had the opportunity under the statute or under Rule 56D, it may have been 56G then, we filed these 2 years ago. He had the opportunity to ask for discovery, he didn't. And so those facts are unrebutted in this record. Those facts that Jennifer Abrams didn't direct, control, authorize, ratify, or have anything to do with these statements, those are unrebutted on this record. And that's enough for the court to grant a summary judgment order in favor of Ms. Abrams. But if we go back and we look at the anti-SLAPP, and we joined in the motion, and I endorse the arguments that were made by Mr. Cwik on behalf of the co-defendants, the way that this case should be resolved at this point is for the court to grant the anti-SLAPP motion. The allegedly defamatory statements, if you look at the context of what was happening with Plaintiff in his divorce and his comments about the corruption and the unfairness and the denial of due process rights that he was receiving in the court, it's all relevant to this political discussion that was ongoing between two competing organizations. It's like you have Republicans on one side, Democrats the other. They're not a party affiliated, but it's the same kind of thing where, hey, we're right because we think that such and such judge is corrupt and he should be removed from the bench. Or the other side say, no, they're great judges. Well, now when people make statements like that in a public forum, it's appropriate to let people know if someone has an axe to grind or if there's some other motivation for why a person's making a statement like that. And I think kind of a notorious example that I can give of this is the court will recall, if you go back to, I believe, the 80s or early 90s, there was a man who ran for the Senate in Louisiana. And he maintained very harsh views regarding Jews. He was anti-Semitic, regarding African Americans. He wanted to deny rights to people like that, deny funding and programs that would help support people like that. And commentators pointed out that David Duke is in the Ku Klux Klan. And if you have that kind of attachment to your name, then I think people can discern, well, this isn't a politician I want to vote for. These aren't beliefs that I want to endorse. And it's the same thing. Someone who is constantly just publishing a diatribe about judges because they don't like the decision that they've received in their family law case, the audience is entitled to know that, well, there's a reason that this person's writing like this, why they hate and attack the family court system, why they think that the family court system is completely corrupt. And that's because they're losing every motion, every aspect of their case. Mr. Phillips would have you believe that his family law case was a garden variety family law case. I don't think so. Garden variety cases don't involve suing the judge. They don't involve threats of violence against your spouse or threats against a school or threats against a child or anything like that. That's not garden variety. They don't have TPOs. Garden variety is you show up, you cut a deal, you put it on the record, and that's it. The court never sees you again. You don't have to come in every week for a motion. So someone who's got to go to court every week on their motions or has to constantly fight every turn and they want to criticize the system, people are entitled to know that. And so that's what happened here. And that's why this falls right squarely within the anti-SLAPP statute, what was intended by the statute. People are entitled to have a political discourse, and you can't sue somebody because you don't like what they say if the statement's made in good faith or without knowledge of the falsity. And if you look at the statements that he's challenged, and you consider the gist, you don't strip it away, but you consider the gist of what's going on in his entire family law case, then there's really no basis for this case to proceed. And the court has Exhibit E, It's very unusual that there would be a 68-page decision in order in a family law case. But that's what Judge Ochoa did. He spent a lot of time taking testimony, evaluating evidence, researching the law, and drafting a very comprehensive decision in order. And I'm not going to sit here and read it to your honor,
I've
but
got it in front of me.
if you look at some of the findings that are made in this, as a voter or someone who's in the public hearing that, hey, Judge Ochoa is a bad guy, I'd certainly want to know that Judge Ochoa made all these specific findings. And so that's why I think it falls right within the S.L.A.P.P analysis. And I'm not going to read it because it speaks for itself. It truly does. So unless the court has questions,
No, thank you.
thank you, appreciate it.
Your Honor, can I just address one thing?
I think you've exhausted me. Let's go to Ms. Phillips.
If it please the court, would Your Honor wish to order a break at this time? Because I probably would be going for a while here.
Oh, sure. We'll take 10 minutes.
Thank you, Your Honor.
You ready?
Yes, Your Honor.
Okay, back on the record, Phillips versus Abrams.
Well, if it please the court, may I be seated? 'Cause
Oh,
I-
sure.
Okay,
Yeah.
just might be a little more comfortable here. Just to begin, if I may, I wanted to address some of the things that they've said that I just think are so completely outlandish here. In addressing, first of all, the issue with Jennifer Abrams and her involvement, as we allege in the operative complaint, the second amended complaint, that Jennifer Abrams benefits from the statements made by her employees. Because what's really happening here is all this nonsense about politics and veterans in politics, and there's nothing here to do with politics. It absolutely has nothing to do with politics. This is a debate, an ongoing debate between those people that are in the family court system, like Jennifer Abrams and her employees, who profit handsomely from being family court attorneys. And they are bitterly opposed to anybody who calls for reform. And I heard, Mr. Garin say that I'm just mad about losing in family court, and so I'm trying to, sour grapes, trying to just sue other judges and so forth. But the point I wanted to make about Jennifer Abrams is that these posts were made during business hours. And on the issue of vicarious liability under defamation cases, it's clear that if the defamations are made during business hours and if they benefit her, which they do, then she's going to be on the hook for liability. Now, she benefits from this because at the end of the day, all the smoke and mirrors about politics is just smoke and mirrors. And when the smoke clears away, all we have left is Jennifer Abrams and her vendetta against Steve Sanson, because Steve Sanson was the first to stand up to the family court system and call out some of the shortcomings, some of the unfairnesses that's going on in family court, the unbridled discretion of judges. And I am not a member of Veterans in Politics. I appeared on, I think, 2 or 3 of their talk shows, like many other people have. And they claim that the public interest here is that they want to warn, they want to tell people don't adopt Steve Sanson's message because Phillips appeared on the talk show and Phillips is a bad guy, therefore Phillips's opinions are wrong, and by imputation, I guess Sanson is wrong, and so don't believe Sanson. This is one of the poorest excuses I've ever heard for public interest. In fact, if you look at the piping rock factors that my colleagues quoted, there's one about that it can't be a broad amorphous interest. If all they can cite to is some broad amorphous interest, it's really not a matter of public interest. They're talking about the judiciary and politics, but what is the issue? Is the issue like one side wants to build the border wall, the other side is against the border wall, one side says equal pay for women, the other side opposes it? No, what's happening here is One side is a family court attorney, and whenever someone like myself decries the family court system, they defame that person. And that's how I first came to learn of the Nevada Court Watcher situation, because I got cheated in family court on many things. And it's not just sour grapes. I don't want to go too far into this, but Judge Ochoa had issued a restraining order on me saying that there was a restraining order hearing and that I was present in court. The entire document was false. I was never in court. There was never any restraining order hearing. The judge just sua sponte issued a restraining order. Now, I think that's a severe lack of due process. There's massive federal civil rights violations and ongoing fraud by the court when he phonies up a court document. I have a right to speak out against things like that. There are many people who speak out against the family court system. In this country, there must be 4,000 children a day, they average, that lose a parent to the family court system. The United States of America has like a 24% rate of children living in a single parent situation, when the world average is about 7%. I believe the family court is tearing apart the fabric of this country. I'm concerned also about some of the lack of constitutionality in the family court. I want to be brief about this, but I want you to understand the nature of these arguments. And I made these arguments in the Nevada Supreme Court. They never responded to them other than just to affirm the lower court. In fact, I've never had a judge that would respond to the arguments I'm going to announce right now. One of the things I oppose is the fact that there's no presumption of innocence. I see this all the time. A fellow called me the other day saying he saw cops on Fox TV. All suspects are innocent until proven guilty in a court of law. Well, shouldn't a family court parent be presumed innocent? How can a judge make a sua sponte finding that a parent commits a crime? I don't think that that's consistent with due process. I'm also opposed to this idea of no strict scrutiny. We understand, I do a lot of constitutional law, I'm licensed to practice in the United States Supreme Court, and we understand how constitutional law works. When a constitutional right is taken from somebody, there has to be strict scrutiny analysis. Is this order, in case of my situation, the custody order, is the taking of my right as a parent, and the 14th Amendment liberty interest says that parenting is a fundamental right, kind of like abortion used to be under the liberty provision of the 14th Amendment. And I believe that if they're going to take away someone's child, the custody order should be narrowly tailored to effectuate a compelling governmental interest, and it has to be done by the least restrictive alternative. Meaning, if someone thought I committed domestic violence, well, arguably there's a compelling state interest in stopping domestic violence among spouses. I think a keep-away order between me and the spouse would suffice. Why are they taking away the minor child? They're only doing it as a means of punishment. And we know that under Nevada law, a change of custody is not supposed to be used as a sort of punishment. Well, it was used as a sort of punishment against me and many others. And this is how this whole thing started, because I'm talking about we need strict scrutiny analysis, that parents should be presumed innocent, that when they find someone commits domestic violence, it shouldn't be by a mere preponderance. Domestic violence is a crime. And if a judge is going to make a legal conclusion that a person commits domestic violence, well, I believe the finding should be the constitutional standard, beyond a reasonable doubt and to a moral certainty. But they don't do that. I had a restraining order issued against me, and it was issued on the lowest evidentiary standard known to mankind. We know that when they issue TPOs in Nevada, it's based on reasonable suspicion, and that's lower than the preponderance standard. So essentially, I was found to have committed domestic violence by less likely than not evidence. But the point is that they're not talking about the domestic violence, they're talking about something completely different. Threatening to shoot up a school is a serious felony. It's a terrorist act. It's not domestic violence anymore. You know, they talked a lot about the C-Lig
Mr.
case.
Phillips, why don't you do some discovery on this issue? My hands are tied on this. I'm bound by what the record shows. Why didn't you do some discovery to show at least that this was a false claim? Right now, it looks like it's a true claim according to Judge Show.
Well, I don't think it does look like a true claim, and let me explain why. Your
Well,
Honor,
it's a finding by a judge. And it was never appealed.
it was appealed, but it was basically ignored. The point is that Your Honor had asked, how did this all start? All we got to do is look at their motion for anti-SLAPP. Your Honor asked about where this had come from. If you look at page 3 of their anti-SLAPP motion, I would read from it there. On page 3, they say it was plaintiff's relentless attacks against Schoen and DiCiero that caused Schoen and DiCiero to first research and eventually learn for the first time of the disturbing public available findings in plaintiff's divorce case before Judge Ochoa, including allegations that plaintiff had previously threatened to shoot up a school. Judge Ochoa made a finding of allegations. There were allegations that Phillips had threatened to shoot up a school.
But you had an opportunity to ask for discovery in this matter to show that you did not do that.
Well, I think it's fair to say that it's allegations. If you stand on the record, it says there are allegations. If they felt a burning need to go tell the world and they wanted to honestly...
But it was your obligation, not theirs. That's the way the SLAPP statute is. Believe me, I sat through enough conferences on this statute to wonder, it does trump 14th Amendment in many respects. It does trump the presumption of innocence because it's read very broadly because of the First Amendment. The First Amendment, freedom of speech.
I guess I'm not understanding what Your Honor wanted me to clarify, because I think when there's a ruling that there's allegations, if they were...
I'm asking you why you didn't do discovery. The simple question, why didn't you do discovery?
I just didn't, I actually tried to, I sent them some questions, they wanted to wait, and I figured that I don't need to do discovery here, because it's clear to me that there were allegations. Let's just say for a moment, I found allegations that Jennifer Abrams may have AIDS, acquired immune deficiency syndrome. And I say, hey world, Jennifer Abrams has AIDS. That's not part of the fair report privilege. You have to report exactly what it is. The difference between allegations and not allegations is ginormous. They found allegations that Phillips had threatened to shoot up a school. And these people are family court professionals. They understand that there's salacious, wild allegations flying all the time, and it was simply an allegation. But they didn't report it as an allegation. They reported it as it happened. They said that Phillips threatened to shoot up a school, and that's not the case. If they were acting honestly and they felt a burning need to tell the world, they could say, hey world, there were allegations. Well, allegations don't mean that you did it. Certainly, an allegation is merely an allegation.
But you had a right to take the deposition of both these men, and also a deposition of Judge Joe if you wanted to. I'm sure that no judge would deny you that right. You didn't do it. It makes my job very difficult in this case, very difficult, having sat as a Supreme Court justice on all these anti-SLAPP cases. You haven't seen one that was affirmed from the lower court finding there was no anti-SLAPP.
Well, let me...
Give me one case in Nevada, just one. I mean, I'm very familiar with Tarkanian and Rosen, very familiar, even though I wasn't on the court, because I know both of them so well, and I followed that case as a senior judge, just to see what was happening, because I know both those folks.
Well, I want to say the other evidence that they rely on is the, I'm going to find it here, is they want to talk about the part where it says, plaintiff learned that Phillips made phone calls to the child's school. This is plaintiff being the ex-wife. The ex-wife learned. Okay, well, this is a finding of Ochoa, a finding of what the ex-wife learned. It's not a finding of Phillips's conduct. It's a finding of her state of mind, her present time belief. Of course she's going to believe Phillips threatened to shoot up the school, because that's going to be her ticket to custody if she forms that belief. It says, plaintiff learned that Phillips made phone calls. This is a finding of what she learned. It's not a finding of what Phillips did. This is axiomatic. So, and again, if they really felt a burning need to tell the world about Phillips, they could have said, hey world, his ex-wife learned that he threatened to shoot up a school. Well, again, these are legal professionals. They understand that the Judge Ochoas of the world don't have subject matter jurisdiction to decide terrorist threats and criminal activities. They know that that belongs in criminal court. If I were to have threatened to shoot up a school, I wouldn't be here talking to Your Honor today. I'd be locked up. I'd have an FBI record. It's obviously false on its face. This whole thing is completely false. They're accusing me of threatening to shoot up a school, threatening to bomb a school. They're calling me a school bomber, that I did it. They're calling me a school shooter, and there's absolutely nothing to support that. The only thing on which they're hanging their hat on is the TPO findings from 2018, which said there was an allegation. And then Ochoa later incorporated that, saying there was an allegation that Phillips may shoot up a school.
You know, I was a family law practitioner for a number of years, and there were many times when, in custody matters, one side would allege the other side committed some type of molestation. And you know what? We had extensive investigations because of discovery and because of Child Protective Service and everything. We always were able to either show that it was true or not true. That should have been done in this case, and it wasn't done. It wasn't done. There's nothing there to show that the school did something wrong or made an allegation that wasn't true. And even if it wasn't true, it's enough in the record that they certainly could report it as an allegation.
Well, but an allegation is a mere allegation. They're the fair report privilege. Let's look at it this way. They mentioned the S.L.A.P.P case. Your Honor understands the S.L.A.P.P case.
Very
That was the well-known campaign manager for Bob Dole and for George Bush the Elder, and he was on prominent domestic violence, anti-domestic violence campaigns. As it turned out, he got divorced and his wife alleged domestic violence against him. The Democrats had a field day. At the trial, trying to prove domestic violence by the wife, she got Sippel's 2 ex-wives to testify. So now there's 3 people testifying. Well, the Democrats had a field day. What they did is they took the exact testimony of the 2 ex-wives and they published word for word the testimony of the 2 ex-wives. Now, that's fair report privilege because they're reporting exactly what happened in the proceedings. What if somebody said, hey, Sippel threatened to bomb a school? Well, that's going to be defamation right there. Because in the Sippel case, the reason that Sippel lost in the defamation claim was because, again, what they reported from his domestic violence case was the testimony word for word. If they had gone in my case and said, hey, world, there were allegations, then maybe they can say it's true because there were allegations. They could say that.
These men didn't, they didn't know about, they didn't know anything about falsity, being false. They had nothing to show that it was false. You needed to come forward with some information via discovery. I'm just telling you that. I don't think I'm out of line. I think that I'm right on line about this, that this is what I've visioned that the broad application of anti-SLAPP is, exactly what I'm saying.
Well,
And exactly what counsel said.
Well,
I'm asking you to try to show that he's wrong.
well, can I bring up the Weinberg case here, if I could turn
Sure.
the court's attention to Weinberg? This is a case where I'm reading from the second page here, where it says that the defendants are claiming that the causes action arise from the discussion of criminal activity. The Weinberg case is the same thing. It's a defamation case where they're suing for false criminal allegations. And they contended that there's an issue of public concern just by talking about the criminal allegations. Well, just saying, Phillips threatened to shoot up a school standing alone does not give rise to an issue of public concern. But most significantly, I want to read from Weinberg here. It says, simply stated, causes of action arising out of false allegations of criminal conduct are not subject to the anti-SLAPP statute. And this, to me, is the entire case. Your Honor can end it right here. Simply stated, causes of action arising out of false allegations of criminal conduct are not subject to anti-SLAPP. they really can't bring anti-SLAPP in the first place. Anti-SLAPP was not intended.
The
for
only
some-
thing that you're saying is false allegation is you saying it, that's it. I don't have any other proof, I need some proof, and I don't have it,
Well,
that it's a false allegation.
Well, the point is, it's false because they're not accurately reporting what's in the record. It was an allegation, and they're making it sound like it happened. That's false right there. It's false because it was an allegation, and they didn't report it that way. And I think that at some point, I think people can understand that if I'd really done this, that they wouldn't have closed the police investigation the same day.
Well, let me tell you what I'm relying on. After the parties' final separation, plaintiff was called by the child's school as she was on her way to pick up the child. When she arrived at the school, she saw police cars everywhere. The school required parents to go into the school and physically pick up their children. Police asked plaintiff to step aside when she arrived at the school. They asked plaintiff identifying questions about the defendant, such as what was his birth date, what car he drives, and asked her about her protective order she had against him. At the time of this incident, the defendant did not know why the police were called. However, at the hearing for protective order, plaintiff learned that defendant made phone calls to the child's school and threatened to shoot up the school, which resulted in a lockdown. Also, Judge Ochoa's findings use the word shoot up versus blow up is immaterial, as the gist or sting of the words are interchangeable. It's not refuted at all. I need it to be refuted. You went to the Supreme Court on this and they didn't help you. So I can't help you from the district court. I'd be overruling Judge Ochoa. There's no way to do that, Mr. Phillips. There's no way to do that.
I don't see how you're overruling, respectfully, how you're overruling Judge Ochoa here. The point is that the ruling stands that Judge Ochoa found what was in the ex-wife's mind, okay? They didn't report it accurately. You have to, if you're gonna do fair comment and fair report, if they're gonna talk about a case, they have an obligation to report it accurately, and they haven't done that. They haven't reported accurately. That's what I'm concerned with.
I just think that there was ways around this as far as to show exactly what happened at the school on that date. I think it was, some of the facts are there. I mean, police cars were there. The school did a shutdown. I mean, I would like the principal to have been deposed, and your ex-wife being deposed. I can see there's a lot, I'm a litigator. I need some information other than what the law on anti-SLAPP is. I'm ready to rule, to tell you the truth. I've heard a lot, and one thing I'm gonna rule is that everything that's in the record, the appendix, all of it's in. In other words, everything's in. That way, if you do appeal, it's all there for you. There's nothing, I'm not withholding anything from either side. I want the Supreme Court to, if this case is appealed, to have the value of the complete appendices in this matter, because there's a lot of stuff. I looked at a lot of the exhibits, and some of them are very interesting. And I know about both these organizations because I'm an attorney in this jurisdiction since 1970, a judge since 1999, and a justice since 2007. So I know about what's going on, and this is definitely in the public interest, this type of case, when somebody, especially with what's going on in this country now. Of course it's in the public interest.
Your Honor.
So I'm going to grant the motion to dismiss on the basis of anti-SLAPP as to Schoen and DiCiero. As to Abram, I'm granting not only the SLAPP motion, but also the summary judgment motion since it's unopposed. And I think I'm obligated to do that. There's no information in opposition to that summary judgment for Abrams. So I want both of those for.
Yeah, we also filed summary judgment as both together.
I prefer to just do SLAPP for you, to tell you the
Okay.
truth. Let me just do SLAPP. I'm not gonna, I think I'm correct on this. Also, one of the things I want to say is that prong one was approved, good faith communication and public concern was approved by preponderance evidence by defense. Also, it's my feeling that if I did not find prong one and I went to prong two, that there's not prima facie evidence for a plaintiff to prevail in the claim.
Your
Trying
Honor.
to save everybody a lot of time.
I don't mean to be rude and interrupt, but I haven't finished what I wanted to say. I don't
Well,
want to be
I think,
forced.
I'm obligated also to look at the pleadings in this matter, and I could have ruled on the pleadings without you even coming in. I wanted to give you the courtesy. But I don't think you're heading in any direction that would change my mind. So that'll be the order. I need defense to prepare the findings of fact, conclusions, laws to both Abram and as to the two other defendants. And I think that would give Mr. Phillips a chance to do an appeal to the Supreme Court on this anti-SLAPP issue. I think that I have to review this very broadly as what the law in Rosen and Tarkanian says, and Shapiro and Welt. I mean, these cases are obvious, and this is it's a sad situation. I think it's very sad that these two organizations are vying against each other over a family law matter. But once they did that, it became in the public interest because of Facebook and because of LinkServe. So I think
Your
that they've done everything. What else?
I am sincere, and I think Your Honor respectfully is missing an important point.
Good.
When you talk about
That's
the
what appeals are for.
when the piping rock factors, they specifically say that there has to be a nexus between the purported public concern and the statement. I wanted to go through with Your Honor these 17 statements. All they do is they say Phillips is a school shooter, and they never say, don't vote for Measure A because he blew up a school. Don't vote for Linda Bell because Phillips is a bomber. They're not tying in this public concern. There has to be a nexus,
I
and they're
believe
not.
there is, Mr. Phillips.
Okay,
Yes.
all right, fair enough.
And it'll be an issue for the new members of the Supreme Court. I think they'll be very interested in seeing an anti-SLAPP statute that comes from Judge Sherry. They'll be very interested to see that he felt that from prior experience with this statute that is broadly read, and that the First Amendment prevails in this country. It really prevails on these anti-SLAPP statutes.
Your Honor, can we get 3 weeks to prepare and,
Much time as you need. I'm not going anyplace.
okay, because I think we probably want to spend some time together doing it.
Please do.
Okay.
It's only fair for Mr. Phillips that you have a good order that he can appeal.
Okay, very good.
And it doesn't bother me if you want to appeal. I think it's a good idea because maybe the court needs to talk about some of the things you talked about, including the presumption of innocence and the fact that this was a criminal allegation. It certainly was a criminal allegation. So there's issues at the Supreme Court. I'd be interested to see how they're going to handle this thing on appeal. I wish you the best, Mr. Phillips.
If I can
Thank
make
you, Your Honor.
the closing thought of Your Honor, I want to create an adequate record. I feel like I've been rushed and haven't had a chance. I know Your Honor's made up your mind, I get that, but the part that I'm stuck with here is we know that when the First Amendment does not operate as a defense to defamation. This is defamation per se. They admit making these statements, and they admit making it, if you look at paragraph 16 of their declarations, with the reader understanding that I'd involved in criminal activity. They're saying that. That's their intent. They know that the reader, this is them speaking, that when their words are going to be interpreted as me having committed a crime. This is defamation in and of itself. And so there's not going to be First Amendment. That's what Weinberg says.
I don't agree with you. I don't agree with you at all. I've seen the application of anti-SLAPP. That's not the application from the state of Nevada or from the state of California, as far as I know. That'll be the order. Thank you very much, everybody.
Thank you, Your Honor.
Your Honor,
We're in recess.
have a great afternoon.